Good morning, may it please the court, Jack Ryder on behalf of Walmart. Your Honor, in this case, and I'll reserve 5 minutes for both, Your Honor. In this case, it is, we believe, clear that Walmart is entitled to judgment as a matter of law, and the trial court should have directed a verdict for Walmart. If a premises owner obviously has 2 duties: to maintain the property in a reasonably safe condition, or to warn of dangerous conditions. And starting, and of course, it's critical that a property owner's conduct is measured under the rubric of reasonableness. What is reasonable under the circumstances presented, which can be determined, of course, as a matter of law. And if we start off, and I do want to start from the premise of the warrant, because here it is indisputable that Walmart presented a warrant.
The verdict form didn't distinguish how Walmart was negligent, did it? It didn't give a choice between warning or maintaining it in a reasonably safe condition.
I don't believe so, Your Honor, but quite honestly,
Yeah, that's my recollection.
I believe that's accurate, Your Honor, but I start from the premise of the direct.
So even if we would agree, okay, they warned, the cones are fine, you still have to maintain the premises in a reasonably safe condition. And I don't want to derail your argument, but I kind of go back to thinking about what the trial judge said, is how is it not a jury question as to whether or not Walmart maintained its premise in a reasonably safe condition?
Here's why, Your Honor. Case law, such as the Dominguez case, which we cited, and other cases have found that when a premises owner operates and acts so reasonably under the circumstances, that can be evaluated as a matter of law. And so to answer your question as to why is that not a jury question, it's because here the facts, the undisputed facts make clear that everything occurred in minutes. Minutes. The rain started. You have the assistant manager calling out for assistance in terms of the placement of anti-slip preparations. Immediately, Ms. Valencia is putting down cones, 3 orange cones. We have Ms. McCracken admits that she saw the cones. This isn't a case where there was an inadequate warning. Ms. McCracken said she knew it was raining. She admitted she saw the cones, and she stepped over a cone. The entire course of events from the beginning of the rain to the fall was between 2 to 3 minutes, and that's evident from the video. So the
floor got pretty wet pretty quick.
Your Honor,
I mean, that's an inference the jury could draw from watching that video, because it went from being dry to pretty wet very fast.
And well, Your Honor, I assume that that floor was wet enough to create this.
Well, you can see the water.
Well, that's right, Your Honor. You can see water.
Right.
So did Ms. McCracken. I mean, that really goes to
That goes about, doesn't that really go to her negligence? Whether or not she was negligent?
no,
And there was a discussion, I had used an opposing argument, she was walking too fast, she had on the flop. She saw the water, she didn't slow down.
So there are 2 things I would say about that. I think it's important to always remember respectfully that a property owner is not an insurer of the safety of its invitees. That the goal and the standard is to act reasonable under the circumstances. This is not.
Well, let me just stop you. I understand that, but I'm trying, if you would have to view the facts in the light most favorably, Ms. McCracken, and draw the inferences in her favor, couldn't a reasonable jury infer that there had been Walmart knew about how slippery these floors got when they were wet? They had a number of slip and falls. They knew they needed to put rugs out, mats out, and the floor got wet really fast. So that, you know, I mean, there's a big emphasis on they didn't have enough time. Well, maybe they should have, maybe given the knowledge they had, couldn't a reasonable jury infer that they should have kept those mats out there all the time, or it just wasn't reasonable to allow that floor to stay wet for any length of time?
That would place a strict liability burden on a landowner, Your Honor, to suggest that because the law makes clear that there is an opportunity of that it's measured by reasonableness, and the goal is to immediately attempt to remedy the potential risk. But I think, Your Honor, what makes the case one for a question of law or at a minimum, my argument here is entitled to judgment as a matter of law, or at a minimum, a new trial. And here's why. What you just identified, Your Honor, really dovetails very critically into the issue of the improper testimony of Russell Kenzie. Because the question isn't whether or not the floor presented a slip risk, whether or not the floor was slippery and wet. Case law, abundant case law finds that any floor can become slippery when wet. And it's a matter of common knowledge that if there's water on the floor, it can create slip risk. The question is not whether or not, but everybody knows that, Your Honor.
Right.
So
not only did Walmart know it, your employee Davila, Davila, testified that during the previous 8 months, he witnessed slip and falls in this situation because of rain between 6 and 8 times. So not only did they know it, they had an experience with it. And that's troublesome because, and you couple that with the expert witness, Ms. McCracken's expert witness, Kenzor, I don't know how to say his name exactly, where he testified that, porcelain tiles are slippery, but you can maintain them, but carpet would be better. I know you take a big issue with that coming in, but we need an expert to tell us that carpet's not as slippery as porcelain tile. don't you think anybody knows that?
Absolutely not, Your Honor. Respectfully, it's not about whether or not a carpet would have been better than tile. I would submit when you.
Yeah, but it's a question, it doesn't ever mean that.
No, Your Honor. No.
And my question also relates
Mr.
to,
Ryder, you got uphill battle with that argument. Carpet, tile, but what tile can be less slippery.
hang on, but what's important about that point that we're all sort of giving you a hard time about is your own employees said, the last 8 months, we've had 6 to 8 of these. And knowing that common sense tells you carpet's better than tile, shouldn't Walmart have shifted to a carpet entryway?
So I will answer that. And the answer is, it's not the standard upon which we measure whether or not a premises owner acted reasonably. This is why it's not whether or not carpet is generally less slippery than tile. The question is whether or not this floor was unreasonably slippery. Not whether or not it could be a slip risk, but whether or not it as presented, as designed, was unreasonably slippery.
Well, I mean,
I don't think that was the question.
yeah.
Well,
No, the question was, did Walmart act reasonably?
well, that's right, Your Honor. But the question to suggest that Walmart should have acted reasonably by reconfiguring its stores or changing the flooring is not a matter, I would submit.
Well, I mean, what about a jury deciding, hey, you want to have this slippery tile that apparently gets wet pretty quickly? You want to have it? You get your mats out there fast.
Your Honor.
And if you don't have them out there before the floor gets wet, it's just not reasonable.
Well, Your Honor, the cones and the mats were put out within minutes.
But the floor was wet, the floor was already wet.
And you know,
Excuse me, I don't need to talk over you. At page 682 of the transcript, Ms. Valencia actually testified that the rain was starting just as she was putting the mats. So there is testimony undisputed that the rain was coming down as Walmart is acting, because as the testimony made clear from Mr. Davila, he didn't wait till the rain started. He called for assistance when he saw it getting dark outside. So I just want to make sure that I make that point to the record. This is not a case where they waited till the rain was falling. They saw the skies darkening, they started to act.
and what you did do with 6 or 8 prior experiences in the preceding 8 months, you still didn't do anything to fix the problem. No matter how quickly you moved, you should have moved months ago to change the entryway to make it safe.
And my position on that is I think that unfortunately falls happen. And whenever a floor gets wet, it creates a slip risk.
So maybe a reasonable juror could say, that, you know what, in this situation, it's not reasonable to leave those bare floors out there. And every morning when Walmart opens up, they should drag the mats out and lay them out, because we know in Florida it rains suddenly and unpredictably. Why wouldn't the jury be able to come to that conclusion and it be reasonable?
And my response to that, Your Honor, is that I think that when you look at cases like this court decision in Walmart versus Whitby, where Judge Silverman, you were concurring, one of the concurring opinions on that, or you concurred in the decision, I should say. When we look at cases like Walmart versus Whitby out of this court, we look at Dominguez versus Publix. These are all stores that have tile floors. Tile floors, Mr. Kensler, their expert, who we believe clearly had zero methodology to support his opinion about the unreasonably slippery nature of the floor. All he
Isn't slippery enough,
no,
isn't saying unreasonably slippery, I don't even understand that, that's
I'll
just
explain.
red herring.
no, I'll explain. In Rosenfield versus.
I mean, is there like a reasonable slippery floor?
There is, Your Honor, because
Okay.
this is the point that I was respectfully trying to make, is that every floor creates a risk of slipping. That is why.
Yeah, but this floor, we know is really slippery because people keep falling on it.
I don't believe that the testimony suggests that this floor is any more slippery than other department stores or supermarkets, where if there's water on the floor, unfortunately, it presents a risk. In Rosenfield versus Oceania, the 11th Circuit talks about the concept of slipperiness. There is a huge distinction, Your Honor, respectfully, between slippery and unreasonably slippery, because the standard is still reasonableness.
What was the setting in that case? Would you remind me?
Rosenfield?
Yeah.
It was a pool deck, I believe, or stairs involving where water would collect. And the expert in that case talked about the fact that or the 11th Circuit determined that in order to have a finding that a floor is unreasonably slippery, it requires an expert witness to talk about the coefficient of friction.
I think it was because of the nature of the material there.
Yes, it was the nature of the floor, the
Right.
bolted.
Whereas here-
It's called.
You know, I mean, I know they brought in an expert, but seems to me anyone with some common sense could deduce that anybody that's ever walked on a wet tile floor understands it's slippery.
And to that, Your Honor, the issue is not whether or not it was slippery, it's whether or not it was unreasonably slippery.
Yeah, but if someone slips and falls on a floor and really hurts himself, isn't it ipso facto unreasonably slippery?
No, Your Honor, it is, I respectfully disagree. That is, I believe again, that is sort of the flaw that Mr. Kenzier's testimony represents. Mr. Kenzier, who's supposedly an expert, admitted that he never tested, well, he may have the qualifications, but to be clear, he admitted that he never tested the floor. He had the Dixit of, well, how do we know that the floor, well, if somebody slips, it must be slippery, not only slippery, but unreasonably slippery. And Judge Morris, unfortunately, every floor presents a risk of fall. Anybody can fall.
I doubt this one does, this nicely carpeted floor, you'd be really hard pressed to slip on that.
You might be, it certainly presents a greater coefficient of friction. But to determine whether or not there is an unreasonable danger, a unreasonable risk, going back to the point that a premises owner is not an insurer of the safety of its employees, the goal is to act reasonably. And here, I do believe that Walmart acted reasonably in the speed with which it acted. But in addition to that, we've got a clear warning. And cracking of the risks of harm. She stepped over the cone.
But do we have to consider that? I mean, when we're thinking about what Walmart acted reasonably, I mean, isn't that a separate inquiry without looking at the fact that there were cones up?
Well, no, Your Honor, I believe the fact that cones were put up is the essence of the reasonableness with which Walmart acted. I don't think it's that.
Well, that didn't stop people from slipping.
Unfortunately.
That's not what the cone is designed to do. It's designed to alert you to a hazard.
That's correct.
So you can look out for yourself. Right?
Correct. Yes, I agree.
Okay, and so that goes to Ms. McCracken's, negligence, right?
It does, but in the rookie case, the court explained that some risks can be so open and obvious that supersedes the duty to contain. I'm not arguing that necessarily here, Your Honor. What I'm suggesting is, as Your Honor noted, the water was evident on the floor. Ms. McCracken saw the water on the floor. Ms. McCracken saw the cones. I'm not suggesting that
the area where she walked, she didn't see water.
she did say that, Your Honor. Yes, she saw the cone.
She thought there was water on the floor, but not in the area where she was trying to walk to.
That is correct. The cone preceded her, which, by the
And we
way,
can also say that the procedure Walmart typically follows is get the match down and then worry about the signage. And that was done in first order in this situation.
there is testimony about what was the standard in terms of internally as to what comes first, but as your honor in the wiki case noted, when you concurred in that decision, internal standards do not dictate whether or not the reasonableness in the actions.
No,
taken.
but it is evidence a jury can consider as far as whether or not the maintenance people or the individual, the woman who was trying to get this all set up.
I agree.
Whether it was reasonable, whether her conduct was reasonable in light of the circumstances.
I agree with that, Your Honor. I'd like to-
You're right for 5 minutes. Go ahead and finish that answer, but absent any other questions, you'll have your 5 minutes.
Thank you, and I'll just take 1 minute to my rebuttal to make clear that the alternative relief we were requesting is a new trial. Because Mr. Kenzior's testimony, which goes to the heart of the issue of whether or not Walmart's flooring was unreasonably slippery, which again, I believe is an absolute critical component of the plaintiff's case. I believe that because Mr. Kenzior admitted that he never tested this floor, he admitted there was no identified methodology that he could provide. He basically said, how do we know the floor is slippery? Because somebody slipped. And it's not about whether or not the floor is slippery. It's about whether or not it is unreasonably slippery, such that it presents a greater risk of harm. Anything else would make Walmart be sure of a patient safety. And while obviously we do everything we can, the store will do everything it can to do its best, reasonableness is the standard. And that is why the expert testimony, certainly under the post error standard, so unduly prejudicial that at a minimum the court should remand for a new trial. And I appreciate that. I'll say the rest of my remaining time for
Sure, you'll have your 4 minutes.
Thank you, thank you.
Thank you. Please record Shay Moxon on behalf of the FLE, J.P. McCracken. This in short, the court should affirm because there is easily enough evidence for the jury to find that Walmart breached either its duty to warn or its duty to safely maintain or both. And Judge DeRocket did not commit any abuse of discretion in admitting either of the 2 expert opinions that Walmart challenged. The sufficiency of the evidence issue, certainly the court understands our position here. So some things I just want to correct, some statements I heard. I heard Mr. Ryder say that Ms. McCracken saw the cones that were put out. That's not true. She saw one cone that was inside the store area, not the vestibule where the wet spot on the floor was. Is inside the store, just to the left of the door that opens into the vestibule. So it was on the far side of the vestibule, in a different part of the store. I would guess it was at least 15 feet away. And Ms. McCracken testified that when she saw that cone, she paused and she was confused because the floor there was dry. So that cone did not warn of anything. It was put in a different part of the store and it was put on the dry part of the floor. It gave no warning at all that there's going to be a wet spot on the opposite side of the vestibule. And she did not see any of the other cones. There was only one cone that Walmart put inside the vestibule, which was closer to the back wall, not close to the door that was where the wet spot was, and it was pushed off to the left. And because these are very short cones, they're only about a foot high, which Mr. Kenzior testified is not the proper industry standard, it wasn't conspicuous at all. So Ms. McCracken walked by it without seeing it because she was looking straight at it. No, that was the one inside the store. That was the one inside the store. She stopped. You can see in the video. She paused a little bit, looked down, stepped over it. This wasn't even inside the vestibule.
Well, I don't know how persuasive I'm finding the fact that it was inside and not in the vestibule where it was wet. Right? I mean, I think the argument that we made that the purpose is to warn you of danger ahead, not on the spot where the cone is.
Well, it wasn't even close to the wet spot because it was on. The wet spot was on the far side of the investigation.
Now, we know she saw that, right? Admitted she knew that she saw that, so it doesn't really kind of neither here nor there because you saw it,
He saw it,
right?
and she paused, he saw that the floor was dry. You can-
No, but she also saw the floor was wet up ahead, right?
No, she did not. She clearly testified. No, she did not see the wet spot on the floor. That was at page 800 of the trial.
I thought she did testify that she did, that the floor was wet.
Yeah.
Walmart asked her a series of questions that came close to, the implication was that she should have figured out that it was wet. She was asked, well, you saw that it was raining. Yes. And
I recall at some point she testified, she saw that the floor was wet, was wet. And I understood that she was trying to avoid those areas, and where she fell, she didn't see that specific area was wet.
well, you know, I am as infallible as anyone, but this is my firm recollection, is that there is only one wet spot that anyone knew about. It was only that spot by the outer doorway, and that she testified unequivocally that she did not see it. Because, and recall that as she was walking from the inner door towards the outer door, Walmart had put down a mat against the dry side of the vestibule. But it was too short to reach across, so.
Here's what my notes,
There,
my notes reflect. That she testified she knew it was raining, knew people could track water in.
Yeah.
And knew the floor mat did not cover the whole vestibule.
correct.
I don't see anywhere where she specifically said she knew the floor was wet.
Well, yes, and in my brief, I cited page 800 to the point. I checked, I was reading the transcript and occasionally I make a mistake, but I'm pretty confident about this, and I think I looked at it the other day. 800, she said she did not see the wet spot on the floor where she slipped and fell. So,
Well, can I just ask you to shift gears and talk a little bit about whether, would you address the unreasonably slippery floor point that appellant was making? I know that's addressed in the briefs, but I need you to refresh my recollection about what your response was to that. And also, well, let's do that first. And I'll come to the question.
the difference between slippery and unreasonably slippery, is that the issue there? There's.
Well, I mean, isn't that not a point?
Yes.
I think that was your argument, but I can't remember the
You're
exact details of your response to that. And I'm asking you to refresh my recollection. I
Yes.
feel like you responded to that unreasonably slippery argument in your briefing.
Yes, and I will, let me issue some case law on that. Well, just to start, I haven't seen any case that has ever said, and by a Florida court, that has said that somebody was not able to prevail in a slip and fall case because although they slipped and fell and into your floor and injured themselves, sure, that floor was slippery, but it wasn't unreasonably slippery.
Well, that's kind of a question I asked.
Yes,
As
so-
I said,
Starting with,
isn't this slip and fall
Correct.
a factor unreasonably slippery?
yes, and I have some law to back that up. First, I'm starting out with the absence of law, backup law exposition. Also, the slip and fall statute, the current one, 768.0755, sub 1. It's kind of, the first sentence is kind of long, but it equates situation if the dangerous condition. If a person slips and falls transitory substance in this establishment, the injured person must prove that the business establishment had actual or constructive knowledge of the dangerous condition. So that statute equates slipping and falling on a transitory substance with there being a dangerous condition. I cited cases that do the same thing, like Laidlaw versus Bristol, where somebody slipped on track in rainwater in a Bristol, the hamburger place. Moshne versus LaSalle Partners, where somebody, I didn't cite it for the proposition, I cited it for something else. Somebody slipped on water in a bathroom floor, that refers to it as a hazardous condition. Laidlaw refers to it as a dangerous condition. And one case that I was a little hesitant to cite because it has been to large extent superseded by statute, but not on this point, I would submit. It's cited within the Brookie case that Walmart relies upon, and that's Owens versus Public Supermarket, and it is quoted on page 1135 of the Brookie decision. And the key sentence, the first part of it begins, the existence of a foreign substance on the floor of a business premises causes a customer to fall and be injured is not a sick condition. And the rest of the sentence has been superseded by statute. And that's where the court continued to say the existence of an unsafe condition creates a rebuttal presumption that the premises owner did not maintain the premises in a reasonably safe condition. There are a couple of statutes that look at that. So the presumption is that this condition is dangerous.
Let me ask you, we saw the video and the floor went from dry to wet. And in that small increment of time, Walmart was already out there. I understand you think what they were doing was inadequate and that was in the wrong place. They were working to get the mats out, get the materials out that they needed to set up the cones. I understand you don't know where they put them, but they went into action even before the floor became wet. So why respond to their argument that to require any more than that from them, that immediate action, we are on it, is to make them an insurer of the safety of the patrons to the store?
Well, in short, they have plenty of time, and I can into 3 time frames there.
Well, they didn't have plenty of time because they didn't get it done.
Well, yes, but they should have started sooner. I submit that the shortest time frame, supported by the evidence, construed in a light most favorable to Ms. McCracken, is about 7.5 to 9 minutes before their accident. Because I discussed.
Is that when he called, he saw that it was dark? Are you starting time at that point?
That is when
manager called.
the videos. The 9 minutes is when the videos show that customers are walking through the parking lot carrying folded umbrellas in their hand. So the inference there is that at that point, people can see that rain is coming. And then 1 minute later, which is 7.5 minutes before the fall, people are walking through the parking lot with open umbrellas. And so although you can't see, the resolution isn't enough to actually see the rain falling, you can see one person after another coming through the parking lot carrying umbrellas. Some of them come into the vestibule and shake them off. One of them, if you track them, one of them carrying a black and white umbrella, they continue walking into the store. When you see this video in the entrance, holding this halfway open black and white umbrella that you can tell they just had open. There's one point where in the vestibule where there are 3 people in the vestibule who just come in with umbrellas that they were using and they're folding them up. And so I discussed this at length in the back section of the answer.
Yeah, what about the video though? I didn't really. It seemed to me that the people that looked like they were getting out of the rain or had open umbrellas was much closer. Not 9 minutes, but much closer to the time. So I have to review that again, but.
I checked this very carefully, Your Honor, and I wrote the specific times in there. The 9 minutes is people walking through the parking lot with folded umbrellas. 7.5 is when.
When did the manager call? when did the manager call for someone to come and, get mats out?
Well, he estimated it was 1 to 3 minutes before the accident. But my point is that if he was truly watching the sky to see when the
should have
rain
seen
was
it.
gonna start, he should have seen it sooner. Also, Walmart has these policies that tell cart attendants and, people working in the front porch or front part of the store to alert management when they're coming. But again, this is just the shortest time frame, where I suggest it's 7.5 to 9 minutes.
Right.
But really, and this, the court has been on this before, I believe Judge Morris and maybe all of you, is that it really goes way back before that, because Walmart knew that this is an ongoing recurring condition. And so it should have been prepared to get the mats out earlier, to be watching the weather and checking the weather forecast to make sure it's on top of it, so that the mats can be put out before the floor gets wet and be ready.
In other words, in determining whether they acted reasonably here, that has to be done that has to be considered in the context of prior experience
Yes,
with Brandon's floor.
yes,
And to measure the reasonableness of their action in this particular instance, you can't look at it in isolation.
yes, you have to consider what they were aware of, and this intersects with, the doctrine of constructive notice. Now, we didn't, Walmart didn't dispute actual constructive notice, so we didn't read that, but it's a proposition of law that one form of constructive notice is when the condition occurs with regularity and therefore is foreseeable. That's in the statute I cited, and it's also in some of the cases I cited. So this is something that happens regularly and it's foreseeable. Every employee who was asked about this agreed, yes, it's foreseeable that when it rains outside, the front vestibule, people are going to track water into it and become slippery for customers. As Judge Morris mentioned, Mr. Davila testified that there have been 6 to 8 slip and falls during his time there when it was raining. We introduced evidence of incident reports that were uncannily similar to this accident, where there were slip and falls in the vestibule, where where they mentioned, the reports mentioned it raining out, the accident occurred right after the person stepped off the mat. And so they know this happens, and because of that, they had an obligation to get ahead of this. And the corporate representative, Ms. Daly, she agreed that, yes, that they do have a duty to act proactively, to act before the floor gets wet and slippery. And part of that is that all employees have a duty to be monitoring the weather, not just haphazardly looking out the window and saying, oh, the sky's dark, but they're provided a service called the wire that gives them weather forecast, or they can check the weather on the phones. Walmart's written policies, they include, they tell employees to watch for signs of inclement weather coming and to alert management, and to get things to the front of the store to be ready while they're coming. Some other facts that support unreasonable delay here is that nobody helped Mr. Lindsay to put out mats or to mop or put out cones. And then what I would say is the longest time frame of all is something that Judge Morris hit upon and perhaps others. It's the issue of this floor. They set themselves up for failure by choosing to stick with this porcelain tile floor, while all the rest of the industry, big box retailers and stores like Publix and Target have gone to carpeted tile. As Mr. Kempier testified, and he said, sure, you can use carpet tile safely, but you have to be very vigilant. You have to be constantly watching for signs of water and mopping and getting the most mats and cones out. Whereas if you use this industry standard method of floor material for entrances, you don't even have to do that because it doesn't get slippery when it's wet. And so that is the longest time is that and that's how that instance of negligence of choice of tile flooring intersects with everything else. So I submit they have infinite time, but if they didn't, if they really had a time crunch, that's where the flooring material is relevant. I did hear a lot of argument about, the admissibility of that evidence. I would say, just briefly on that Mr. Kensior, he had plenty of a sufficient basis to give an opinion on the, or whether the floor was slippery. There's almost no argument about that. So I would just say, if the court has any questions about the evidentiary issues or the sufficiency of the evidence, I'd be happy to address them. And if not, we ask the court to affirm. Thank you.
Thank you. Right. Yeah, for-
Thank you, Your Honor. Let me start off with this issue of the expert. As I mentioned when I was in my prior argument, one of the key points that we argued is that we believe we're entitled at a minimum to a new trial because Mr. Kensior was allowed to testify without a reliable methodology. What I heard today, what is I think is quite significant, is counsel making the argument that they didn't even need to have an expert because if it's slippery and that's sufficient to demonstrate a lack of reasonableness, then that should be enough to go to the jury. Well, if an expert is not required, then it's a question as to why an expert was allowed to testify in the first place. If the reason why the plaintiff brought Mr.
I actually think that was part of the question I asked. Like, I don't understand why you would even need an expert to testify to this because everyone knows. And I think actually the expert sort of testified to that, like, come on, it's a tile floor. If it gets wet, it becomes slippery. Everybody knows that. I mean, I'm not quoting him, but I saw some testimony that was kind of to that effect.
It is as close to a quote as necessary here, Your Honor. Mr. Kensior's expert, so-called expert testimony was, how do you know it was unreasonably dangerous because it was slippery? Because somebody slipped. The point, Your Honor, is that in response to your question about the issue of, well, is it common knowledge? I go back to the argument I started with, and as it begs the question as to why the plaintiff was allowed to present expert testimony. Why did the plaintiff bring an expert? Because an expert is utilized in cases like this to talk about.
What's the harm?
The harm is extraordinary, Your
Well,
Honor.
it's not extraordinary if everybody knows this.
Your Honor, here's the reason why it's an extraordinary harm. It's the very reason why the Daubert principles apply. It is in fact the essence of Daubert to prevent somebody from putting forth an expert to supposedly testify about something that is common knowledge and to elevate the harm, to elevate the burden on, to elevate the imposition of a liability finding against, in this case, Walmart.
But wasn't that really more for like how to keep the floor safe, how to maintain it safely? As opposed to, I mean, I don't think, in my sense, is it's not a big debate on whether this floor was slippery. And I went back and looked in the brief, and he didn't testify it was unreasonably slippery. So that's, I think I was right. I know you don't agree. But I think that's a red herring. But the expert testimony is, here is how you keep this type of floor safe. This is what is reasonably required for it to be.
The words that Mr. Kensior used was that because of the slippery nature, it was unreasonably dangerous. And that's how he drew the link between the concept of a slip risk and an unreasonable slip risk, because he characterized it as unreasonably dangerous. Why is it harmful? Why is it harmful? I would start from the premise, Your Honor, that under the standard of harmfulness, it is the burden on the plaintiff to demonstrate that there is no reasonable possibility that the introduction of improper evidence didn't affect the outcome. And that burden is not something that plaintiff can meet. Mr. Kensior testified that this floor was unreasonably dangerous, and he did so without any testing. And he admitted that he could not identify the coefficient of friction of this floor without testing it. He admitted that he had no basis for saying it was unreasonably dangerous because it's slippery. And so he said he relied on his experience, his years of experience. That's exactly what Daubert prohibits. So was it harmful? That's up to the plaintiff to demonstrate that it was not harmful, Your Honor. And the plaintiff hasn't even addressed that.
Why couldn't you conclude that it was not harmful based on the fact that there was also testimony that there had been 8 or 9 prior incidents within like 8 or 9 months?
Your Honor, the fact that there were prior incidents.
I mean, to me, that's pretty strong evidence of the nature of the slipperiness of this floor.
So I know, I apologize, I don't need to.
No, I don't need to keep talking, go ahead.
Well, let me quote you because you're about out of time.
Yes.
Answer the question, I'll give you another minute to finish up.
Thank you, Your Honor. The answer to the question is, it all comes down to whether or not Walmart acted reasonably under the circumstances that are presented at that moment. And here Walmart did. I respectfully submit that it is not, unfortunately, it is not uncommon for falls to occur. That's an unfortunate reality of the circumstances. That's unfortunately why it's come up. That's why we look at what Walmart did. As Your Honor noted, Judge Kelly, Walmart acted, they were on the spot. This was like a well-oiled machine. The minute that they saw the sky was darkening, they went into action. They put cones, they put down mats, and Mr. McCracken saw the risk. Now, here, we respectfully submit that at a minimum, a new trial is warranted because Mr. Kensworth's testimony was so unreliable, and the plaintiff has not demonstrated that it did not affect the outcome. Therefore, we ask for reversing remand either with directions to enter judgment for Walmart or for at a minimum, a new trial. Thank you.
Very good. Thank you both. We will take a 10-minute recess and then we will resume if the last 2 cases are on time.
All rise.
Be in recess for 10 minutes.